There has been a lot of talk about proportionality in the law on self-defense, and I would like to begin by referring to the words that Lord Pannick used a few days ago on the test of proportionality. Proportionality does not mean that the defensive force has to be equal to the force that was used in the armed attack. Proportionality means that you can use force that is proportionate to the defensive objective, which is to stop, to repel, and prevent further attacks. Israel has described its war aims as the destruction of Hamas's capability. From a legal perspective, it seems to me that these war aims are consistent with proportionality in the law of self-defense, given what Hamas says it does, and given what Hamas has done and continues to do. On calls for a ceasefire, asking a state that is acting in self-defense to agree to a ceasefire before its lawful defensive objectives have been met is, in effect, asking that state to stop defending itself. And for those calls to be reasonable and credible, they must be accompanied by a concrete proposal setting out how Israel's legitimate defensive goals against Hamas will be met through other means. And it's not an answer to say that Israel has to conclude a peace treaty, because Hamas is not interested in a peace treaty. Proportionality also applies in the law that governs the conduct of hostilities, not only in self-defense. And the law of armed conflict requires that in every single attack which poses a risk to civilian life, that risk must not be excessive in relation to the military advantage that is anticipated. That is the rule in the law of armed conflict. This rule does not mean, even when scrupulously observed, that civilians will not tragically lose their lives in an armed conflict. The law of armed conflict, at its best, can mitigate the horrors of war, but it cannot eliminate them. And the great challenge in this conflict is that Hamas is the kind of belligerent that cynically exploits the rules of armed conflict by putting civilians under its control at risk and even using them to seek immunity from military operations for its military equipment and its military personnel. I think an analysis of the application of the rules on proportionality in targeting in this conflict must always begin with this fact. There has also been some discussion about siege warfare. And I will just refer to what the UK Manual on the Law of Armed Conflict, which reflects the official legal position of the government, it's a document of the Ministry of Defence, says, siege is a legitimate method of warfare. It is unlawful to besiege an undefended town, since it could be occupied without resistance. Gaza is not an undefended town. It is true that there are obligations that apply to the besieging forces when there are civilians caught within the area that is being encircled. And those obligations include agreeing to the passage of humanitarian relief by third parties. But it is not correct to say that encircling an area with civilians in it is not permitted by the laws of war. There is a further point that also concerns the laws of war that I would like to refer to. That is also particular relevance to the British government practice. And it has been mentioned before already that the British government has taken the view, that Gaza remains under Israeli occupation, even though Israel pulled out in 2005. The traditional view until 2005 was that occupation required physical presence in the territory. And that view is consistent with Article 42 of the Hague Regulations of 1907, which state that a territory is occupied when it is actually placed under the authority of the occupying power. And again, it is also the view taken by the UK Manual of the Law of Armed Conflict, which reflects the UK's official legal position, and states that occupation ceases as soon as the occupying power evacuates the area. The European Court of Human Rights in its jurisprudence has also adopted a similar approach to occupation. And so I've always been rather baffled by the British government's position on this issue, which, as far as I know, has not changed. Yes, it is true that Israel has exercised significant control in the airspace and in the maritime areas. But even as a matter of plain geography, it takes two, Israel and Egypt, to control the land access points to Gaza. And more fundamentally, it is Hamas that has been responsible for the government and administration of Gaza. I appreciate that this is a legal matter on which the minister may not want to respond immediately, but it is an important one, because the legal fiction that Israel is still the occupying power under the laws of armed conflict has been relentlessly exploited by Hamas to blame Israel for everything, while using the effective control that it has over the territory, the people and the resources to wage war. On a final note, I'd also like to say something briefly on the way in which the war has been reported. When a serious allegation is made, particularly one that could constitute a war crime, the immediate response of the law-abiding belligerent will be to say, we are investigating. The non-law-abiding belligerent, by contrast, will forthwith blame the other side and even provide surprisingly precise casualty figures.